Assalamualaikum warahmatullahi wabarakatuh. Today I will be discussing about the first question of case study. Question 1. Iman had been appointed as an auditor for her husband's company, Kumaju Sendirian Berhad. Her husband, Kuzain, is a majority shareholder and a director in the company. She prepared the audit report for the company, describe whether the appointment of Iman as an auditor is pursuant to the Companies Act 2016 or not. Issue: does Iman's appointment as an auditor for Kumaju Sendirian Berhad valid under the Companies Act 2016, considering her close relationship with her husband Kuzain, the majority shareholder and director. Principle of law. Under Section 264, Bracket 1 of the Companies Act 2016, an auditor must be qualified and registered. Additionally, the auditor must be independent, with no personal or financial ties to the company's director or major shareholder. Disqualifying relationship, such as being related to a director or major shareholder, prevent an individual from being appointed as auditor to avoid conflicts of interest. Related case. A relevant case is Re-Brabazon 2005, where the court emphasized the importance of an auditor independent to maintain objectivity. In this case, it was found that auditors with close personal relationship with key figures in the company could not be considered impartial. This principle reinforces that any relationship compromising independence, such as being related to a director or significant shareholder, disqualifies a person from acting as an auditor under the law. Applications. Iman, as the wife of Kuzain, a director and majority shareholder, has a close personal relationship with a key figure in Kumaju Sendirian Berhad. This relationship could impair Iman's ability to remain objective and independent, as her personal connection might influence her audit findings. These relationships creates a conflict of interest, making Iman's appointment as an auditor likely invalid under the Companies Act 2016. Conclusion: due to her close relationship with Kuzain, the majority shareholder and director, Iman's appointment as an auditor for Kumaju Sendirian Berhad is likely invalid under Section 264(1) of the Companies Act 2016. This relationship creates a conflict of interest, compromising her independence and objectivity, which are essential for conducting an impartial audit. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Abdullah bin Muhammad Abdul Muhammad. And today, in this video, I would like to explain about question 2 of our case study. Question 2. Khan, an auditor of Bumi Hijau Sendirian Berhad, requested from the board of directors of the company for the minutes of its last meeting, where several controversial decisions were made. His request was turned down by the chairman on the ground that the contents of the minutes were confidential. Khan feels that he cannot make satisfactory report on the company's affair unless he is given the minutes he is requested. Explain whether Khan has the right to access the minutes of the meeting for the purpose of the audit. Issue: does Khan, as an auditor of Bumi Hijau Sendirian Berhad, have the right to access the minutes of the last meeting, especially when they contain confidential information? Principles of law. Under Section 266(1) of the Companies Act 2016, an auditor has the right to access all relevant documents, records, and information necessary to perform an effective audit. This includes books, accounts, and any other documents that may affect the company's financial assessment. Auditors are also expected to act with reasonable care, skill, and diligence as part of their duty to stakeholders. The information needed for this purpose should not be withheld by the board as it would hinder the auditor's responsibilities. Relevant case, Tan Cheng Hock versus Khao Kai Hai and others, 1995. In this Malaysian case, Tan Cheng Hock versus Khao Kai Hai and others, the court affirmed that auditors' right to access all documents necessary for an audit. The case reinforced that auditors should have full access to information that auditors to accurately assess the company's financial position and people prepare their report. Denying access to relevant documents would obstruct the auditor's role, which could mislead stakeholders relying on the audit report.
Selamat sejahtera, nama saya Dr. Suryan Al-Laki Arjunan. Nombor kad saya 04 DAT23F10. Dengan ini saya ingin membentangkan tentang application. Kan 6 meeting minutes for audit purpose. And meeting minutes includes signification financial impact decisions. And also under section 266, access is necessary for an unbiased audit report. Chairman's reviews based on confidently conflict with auditors' legal rights. Therefore, confidently is insufficient to deny access to NCT audit information. And the conclusion is based on section 266 of the Companies Act 2060 and the precedent set in Tan Cheng Hock v. Khao Kai Hai and OS 1995. Khan has the right to access the minute of the meeting. Refusing his access could prevent him from providing an accurate and fair audit report, which goes against his duties as stipulated by the law.